Is no.
All right, we're on the
Check.
record. Before I let everyone know why we're here, we've got one request from the North Broward Jail. North Broward, we'll handle Sandra Neal's case first. I understand she's not feeling too well.
Yes,
Yeah,
Your Honor. Thank you.
let's docket.
Hi, Your Honor.
Hi, Miss Neal. Yeah. Okay. All right, Miss Neal, I'm going to place you on pretrial release, so you won't have to pay that monetary bond.
Thank you, sir.
You're going to have to report to pretrial tomorrow. They're going to give you a map to show you where to go. Have you seen the doctor yet today? Do you need to see the doc before you leave?
No, I'm all right now. I saw the nurse earlier. I had a seizure at Paul Ryan a couple days ago, so
Do you take
I'm okay for the moment.
Do you take medication for that?
It's the crazy girls.
Not at the moment.
Do you need me to have the jail release you with some medication, or you don't? There's nothing you take regularly.
Yeah. Yes, because I was on trazodone at Paul Ryan, but when I came here the second time, they didn't give it to me the second time here, so I don't know what happened. And I'm on some iron pills and a couple other pills. Yes, sir, please.
Do you usually
Just
take
to
the
get me
trazodone?
started.
Usually take
Yes.
it. Is that every day,
Yes,
or
sir.
that's as needed when you have a seizure?
It's daily, but it's not
Daily.
for the seizures. It's for post-traumatic stress.
I understand. All right,
Yeah, it's
so
for something different.
what I'll do is I'll order that the jail release her with a 7-day supply of any prescriptions that she's been taking at the jail.
All right.
Mr. Officer, if you don't mind doing a short
So
order
what's
on
the
that.
standard in any
All
of
right,
them?
and you're
There is
going to
no
be
really
released to the
standard
custody of
anymore.
pretrial.
And on
There's
the
never
other?
been for domestic
And
violence.
the other?
The strong arm robbery.
And then report
Report
in the morning.
You'll be released tomorrow. Yeah, tomorrow morning. And then when do you want to report?
Okay, thank you, sir.
All right, by Monday. All right, you got to report Monday morning, the latest. Okay.
Okay, thank you. You
All
have
right.
a blessed day.
All right, you too. Same to you. All right. All right, you're just on page 2, you said?
Sean Smallcombe,
Oh yeah, that literally is the second case. Let's do
Yes.
that one first, though.
Mr. Linder and I have discussed it.
Okay, good.
Mr. Smallcombe is here. Mr. Smallcombe, come on up. Your private counsel is there present.
All right. Good afternoon, Mr. Smallcombe. You've been charged with domestic violence battery. I'm going to find probable cause for that offense. Your attorney's here on your behalf.
Judge Keith Seltzer appearing on behalf of Mr. Smallcombe. His wife, who's the alleged victim, actually came and retained me today to represent him. She does not want to have contact with him. She
Okay.
has no objection to the court imposing a reasonable bond. I've spoken to Mr. Linder. We'd ask that you set bail at $1,500. He's been a lifelong Broward County resident with no priors. I've also spoken to Mr. Linder that although they will have no contact, that Mr. Smallcombe can have a third party contact her in reference to their minor children and arranging for him to see the children while this matter is pending, and also that he would have at least one opportunity with the Davie Police Department to go to his home and remove his belongings. She has indicated to me that she intends to file for divorce.
Okay.
And I told her I wasn't getting in the middle of those type of communications.
Right.
She came to retain me and solely to advise me of her position. I also told her that somebody from the state attorney's office may try and reach her today to find out her position. She had told me around 11 o'clock nobody had yet. And I spoke with Mr. Linder and they tried to reach her, but she didn't answer.
Yeah, I don't have a problem with any of those conditions, and I apologize if Mr. Seltz already brought this up. It's something we discussed. If you want to make an exception, I don't have any problem allowing him to mail any financial support for her and the children. I have no objection
Won't
to
communicate with
that.
her regarding the case or anything else, and the third party will communicate in reference to making arrangements for him to visit his minor children. The mother brought the minor children with her to see me today. They're 9 and they're 6 years old. They're aware of what happened. They're aware that their father's in jail. In essence, just asked me, when is daddy coming home? That's what the 6-year-old daughter asked me.
I understand.
And I told her he'd be out today. So.
Okay. All right, so I'm going to ratify that. It's going to be a $1,500 bond, and you're going to have no contact with the alleged victim, your wife. Stay 500 feet away at least. And don't call, text, email, write, or find on social media, but you can send monetary support payments. Like your attorney said, you can go through a third party to arrange child custody. If, in fact, your wife or you decides to file for a dissolution of marriage or divorce, The family court judge will arrange for ultimate custody between the two of you and the time sharing of the children. All right, do you understand, sir?
Yes.
All right, all right. Good luck to you.
John, I'll have a bondsman post your bail, okay?
Okay.
I'll take care of that.
All right.
So once that
And when
posts-
should I
Yeah.
when should I be released?
It'll be a few hours. It'll be a few hours.
I would guess in the middle of the night, you'll get released. This is gonna go on the computer
Okay.
now, I assume?
Yeah.
And so the bondsman will post your bail. There's a shift change. He won't be able to post it until after 3 o'clock. So after 3 o'clock, it'll be posted, so after the 11 o'clock shift change, you should get out.
Thank you.
All
You're
right.
welcome, Sean.
All right. Good luck to you. Take care, sir. Thank you, Mr. Seltzer. Nice
Ron,
to see
thank
you.
you. Have a nice day.
I'm sorry, young man. Yeah.
Now, let me just let you all know why you're here. I'm Judge Davis.
Sheila.
This is first appearance court. You're all here because you've been arrested, and under the laws of the state of Florida, you have the right to see a neutral judge within 24 hours of your arrest. I'm not going to be deciding guilt or innocence today. What I will decide is whether or not there was probable cause to arrest you, and if so, I'll set a reasonable bond in your case if it's applicable under the law. You have the right to remain silent. Anything that you say can and will be used against you, so don't talk about the facts of your case today. You also have the right to counsel. If you've hired a private attorney, please let me know. If they're not here, I'll contact them for you. And you also may utilize the public defender's office. There's a representative with you at the main jail and one here with me in my courtroom. All right. Hi, ma'am. How are you?
Hi, good. Helene Reisman on behalf of Christian Reyes.
Oh, yes. I left a message with the office this
Good.
morning. Good. Glad you got it. That was a reset from this morning. Did they stick them back in the pile or do you?
Mr. Reyes is here, President Main Judge.
Christian Reyes.
All right, that's him.
Reset.
Hello, Your Honor.
No, maybe they put them back in my pile here.
Hi, Christian.
Hello. How you doing?
Good.
Thank you.
Yes, that'll be next week.
Is this your signature?
All right, if you don't mind. If you don't mind. Just going to be, did you have an opportunity to see the probable cause
I've
evidence?
seen it now, yes.
All right, good. Just need a minute. We got to get the paperwork back up here. Mr. Reyes, it's just going to be a couple of minutes.
Okay.
And we'll call your case back, okay?
Okay, thank you.
Okay. Marie Prosper.
She's here, President Judge at Main. She's approaching.
Alrighty.
And Your Honor, just letting you, after this case, I have a detective present on the case. Two cases we reset from the line.
Oh, the detective's here? Oh, okay. All right, great. Sorry, I didn't realize. All right, ma'am. You're charged with domestic violence battery. I'm going to find probable cause for the offense. Advocate, have you had a chance to speak to the victim?
No, Your Honor.
All right, Mr. Linder, any priors?
I'm not showing anything. Does pretrial have any notes? Thank you.
All right, Mr. Romero?
Could you put that with the recall, the resets for tomorrow, please?
Oh, sorry, that mic is off.
I apologize. Miss Prosper is 30 years old. She's been residing in our community her whole life. She's currently employed. She works at John Knox Village Nursing Home. She's been employed with that company for 5 years now. She makes approximately $9.75 an hour. Financially, she has no money in the bank. She has one vehicle, a 2006 sedan Pontiac with approximately 164,000 miles. She lives in Margate with her mother. She's been residing at the same residence for 15 years. She has 2 children, ages 8 and 2. She has sole custody of the 2 children. The father is the alleged victim. They do not live together. She lives separate and apart. Judge, we'd be asking you to consider an ROR, considering Ms. Prosper's strong ties to the community.
All right, ma'am, I'm going to release you on your recognizance. You're to have no contact with the alleged victim in the case. Don't call, text, write, email, or try to find him on social media. If you want to arrange for visitation for the children, I understand you have full custody, but if you want to arrange for any visitation, it's got to go through a third party. Do you understand?
Yes.
All right, good luck to you, ma'am.
Thank you. Thank you.
Okay, all right, thank you very much. All right, they're working on it. Okay. Those were from the morning, right?
Yes, Deshaun Williams and Matthew Longberg.
Right. Those
Okay, that was from this morning's docket, I believe.
Yes.
Matthew Longberg. Come on up, detective.
Do you have any children?
All right, and I can have them come up together, Mr. Williams and Mr. Longberg both. All right, let's see here. Mr. Williams, you are charged with the robbery with a firearm and operating without a valid driver's license. And Mr. Longberg, you are charged with robbery of with a firearm. All right, detective, could you raise your right hand for me? You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
All right, put your hand down. Tell me your name, your rank, and the agency you work for.
Detective Michael Benson with the Fort Lauderdale Police Department.
All right, thank you, detective. Go ahead, Mr. Linder, you may inquire.
Thank you, Your Honor. Detective Benson, have you been assigned as the lead investigator in the robbery firearm offense that occurred on February 1st that Deshaun Williams and Matthew Longberg have been arrested for?
Yes.
Could you please tell the court, provide the court with a narrative of the allegations that for the robbery firearm?
Okay, a brief summary of what happened is there was a female walking down towards Los Olos along 8th Avenue approaching, it was Southeast 2nd Street. While she was walking down, a black male approached her armed with a gun, demanding property, her purse. She kind of froze for a second, and this person ripped the purse right off of her shoulder. There was also a white male present during that time. Once the robbery occurred, they did flee westbound towards 9th Avenue and 2nd Street into a waiting vehicle. There was a witness at that location who was able to see the vehicle and see these two people fleeing towards the vehicle with a white male carrying the purse. Approximately 2.5 hours later, this same vehicle was located at the 1500 block of East Los Olos at the 7-Eleven. During that time, Deshaun and Matthew were detained at that point. The witness was brought to that location, and during the show-up, positively identified both Deshaun and Matthew at that location, as well as the vehicle. The vehicle was very unique. It was a 1994, I believe it was a Eagle, very unique vehicle.
A what kind of vehicle?
Eagle.
Eagle.
Very
Okay.
unique. So he did identify everybody. Deshaun and Matthew were transported back to the Detective Bureau, where I did read them Miranda. And post Miranda, they provide a full confession as far as what occurred. Deshaun was very cooperative. Matthew was very cooperative. Deshaun did admit to having a firearm, claims it was a BB gun. Right now, the vehicle is in the confiscation lot of the Fort Lauderdale Police Department, pending a search warrant for the vehicle. So I can't confirm anything about the firearm at this point.
All right.
I do have a few questions.
Go ahead.
Detective, where the witness observed Mr. Williams and Mr. Longberg, could you please tell the court how close in proximity was that location to where the robbery occurred?
So the robbery occurred at exact location of 108 Southeast 8th Avenue, which is pretty much right on the corner of 2nd Street. Once they made the turn on 2nd Street, it's about a block away, where the witness saw the subjects running to that vehicle with the purse.
Okay. And based on your interrogation of Deshaun Williams and Matthew Longberg, after the robbery, who possessed the purse?
Once the robbery occurred, the purse was taken by Deshaun. As they were running, Deshaun did hand it over to Matthew, and Matthew admitted to having possession of the purse.
And also, based on the interrogation, did you discover if there was any conversation or planning of the robbery or a robbery in general before it was committed?
Yes, when they were in the vehicle, Deshaun did admit they were going to do a lick when they saw this lady walking down the street.
They want to do what?
A lick.
And just for the court, could you please tell the court?
Basically, a hit on somebody or a person or a vehicle.
So a lick is street terminology?
Correct.
Okay. And were you ultimately able to recover the purse?
Yes, the purse was recovered. The credit card was used, the victim's card was used at the Hess on Southeast 17th Street, which both Deshaun and Matthew admitted to. I don't know if there's anything else in the vehicle. They said they did dump some of the property while they were driving out the window. The only thing recovered was the purse.
And just so we're clear, how were you able to locate the purse?
Matthew was able to give the information of who had the purse.
One moment, Your Honor. Okay. And do you know if a sworn statement was taken of the witness?
No sworn statement was
Okay.
taken from the witness. There was the show up done with the initial report from that, though.
And as far as you know, was there any equivocation by the witness in IDing Deshaun Williams as Matthew Lomberg as the same people he saw running from the robbery scene?
Yes, when the show up was conducted, I was there for that. When they pulled up, the witness says, yes, that's him. He changed clothes, and now where's the white guy? And then Matthew was identified, and he also did point out the vehicle.
Okay. I don't believe I have. Was the sworn statement taken from the victim where you obtained the factual allegations of the robbery?
I did speak with her one-on-one. I didn't take her statement yesterday. I was actually planning on doing all this today.
Okay. Nothing further, Your Honor.
Judge, may I ask a couple questions? Nothing, just clarification of testimony.
And I just want to know for the record, I mean, we can put whatever term we want, but if you're going to ask questions after direct, that's a cross-examination.
Well, it's our position that the state either has to prove evident presumption grade at a magistrate hearing if they're moving to deny both of them bonds in the case.
Are you seeking to ask questions as though this were an Arthur hearing? Because we're not conducting an Arthur hearing right now.
I was going to ask for an Arthur hearing, yes, to allow me to ask.
Now you want to have an Arthur hearing?
Yes.
I have no objection.
Yes.
All right. Well, let's go off the record for a second, and I'll have both of you come up. All right, we're back on the record. All right, so now state you're seeking foreclosed bond as to Mr. Williams and Mr. Lonberg.
Your Honor, we are seeking a foreclosed bond. It's the state's position first. As far as the lower standard, that certainly probable cause exists. Your Honor, we'd also be arguing that proof evident or presumption grade does exist, not only based on the factual information in the probable cause affidavit, but also the testimony of Detective Benson, specifically the identification of a witness that observed them in the vicinity of where the robbery occurred at the same time the robbery occurred, carrying the same property that was stolen from the victim, and also including but not limited to their confessions made post Miranda to Detective Benson. And from a legal aspect, noting specifically that even though they claim that it was a BB gun, even assuming that is correct, I believe the case law is clear that even if a BB gun is not determined to be a firearm, it can be determined, and it's an issue of fact for the jury, to be a deadly weapon based on the manner of use. And my understanding is the way it was described, the way they may essentially threaten with the BB gun, that it could be considered a deadly weapon in its manner of use in this instance.
Judge, just in response, our position is we were asking for an Arthur hearing at magistrates. It's the state's burden either by they have to, our position is they have to give us notice, file a motion for pretrial detention, to move for pretrial detention. Based on, I just proffering what I would argue if the court were to make a finding either for or against proof evident presumption grade. The detective in his testimony said they still are working on a warrant to search the vehicle that was involved in the robbery. We don't know yet if it was a deadly weapon or not. The second issue is that the finding of fact for the jury, if there is an issue for a fact for the jury to consider, it couldn't be proof evident presumption grade, because that's a standard much higher than beyond a reasonable doubt. We feel that they haven't satisfied their burden, even with the testimony and even with the probable cause. I mean, there are a couple things. The search of the car, I think, is very important to determine whether or not it's a punishable by life offense or not. And I don't think that standard has been established. And based on that, Judge, I would ask the court to respectfully set bond on Mr. Longberg and Mr. Williams.
All right, now do these gentlemen have any priors?
Well, Your Honor, Mr. Longberg is, he's currently out on release for burglary of a dwelling and theft.
All right, he's out on bond?
Let me check to see the specific conditions of his release. Actually, he was released from custody on an ROR. Charges were filed 2 weeks later. He's actually scheduled for arraignment before Judge Singal on February 14th.
All right. I'm going to revoke his release conditions in that case. What's the case number?
The case number is 16-13989, CF10A.
Okay. I'm also going to find probable cause for the robbery with a firearm, and I'm going to hold the gentleman no bond. I'm not going to conduct an Arthur hearing today, sir. Arthur hearing is going to be conducted by your division judge. If your counsel seeks it, you'll have an opportunity then to have a full evidentiary hearing. You're also going to have no contact with the alleged victim. You're not going to call, text, write, email, or try to find her on social media. Stay at least 500 feet away. Now, Mr. Williams.
Mr. Williams is out on bond before Judge Duffy on a grand theft. He is scheduled for arraignment February 13th.
All right, what's his case number?
The case number, Your Honor, is 16-13989. 693 CF10A.
Okay, sir, I'm going to revoke your bond in case 1613693 CF10A. You'll have to sue your division judge about that. I'm going to find probable cause for robbery with a firearm and operating without a valid driver's license. You're going to be held no bond at this time on count 1, and you can seek what's called an Arthur hearing before your division judge on a monetary bond. You're going to have no contact with the alleged victim. You're not going to call, text, write, email, or try to find them on social media. Stay at least 500 feet away. Do you understand, sir?
Sir.
All right.
Yes,
Good luck
sir.
to you both.
And Judge, also, we'd be invoking both clients' constitutional rights to remain silent and not be questioned by law enforcement without their attorneys present.
All right. So noted. Thank you. All right. We have the paperwork now on Christian Reyes. Thank you for your patience, Ms.
Thank you,
Reisman.
Your Honor. No problem.
Have a good day, Your Honor.
All right. Take care. Thanks for coming in. All right,
Hello.
Mr. Reyes, good afternoon, sir. You've been charged with domestic
good,
violence, battery, and robbery without a firearm or weapon. Your attorney is here. She's had the opportunity to review the probable cause affidavit. If I could just have your appearance for the record.
Yes, Judge. Helene Reisman on behalf of Mr. Reyes.
Thank you. All right, I'm going to find probable cause for these offenses. Does Mr. Reyes have any priors?
One moment, Your Honor. Your Honor, I'm showing. He had an arrest in 2015, domestic violence battery. It was against a different alleged victim, and it was dropped. That's all. That is all I'm showing.
It was an improper arrest, Judge. He was not even involved in that, so he's got no priors. He's got close ties to the communities. He's gone to junior high and high school here. He works as a chef for several years at the same location. He actually lives with the alleged victim's mother, who's a witness for him, not her daughter, in the domestic violence case. He cannot afford a very high bond. He makes just a little bit above minimum wage. His mom lives here and owns a trailer with not too much equity. She's going to help him as much as possible. So we'd ask that bond be set, but a reasonable bond so that he could afford it.
All right. All right, sir, I'm going to set a $1,500 bond on count 1. I'm going to set a $3,500 bond on count 2. You're going to have no contact with the alleged victim in the case. You're going to stay 500 feet away. You're not going to call, text, write, email, or try to find her on social media. Do you understand that?
Yeah, yes, sir.
All right, were the two of you living together?
Yeah, but not anymore.
All right, well, if you have any belongings at her residence, you can go on a one-time basis with law enforcement to retrieve them. You understand that?
I understand.
All right, good luck to you, sir. Thank you for coming in, counsel.
Thank
Nice
you.
to see you. Joseph Rivera Weinman.
Judge, I've been advised it's a medical reset.
Okie dokie. Friday a.m.
Don't look at the screen. I don't want to get either one of us.
Steve Mitchell.
Mr. Mitchell's here present. He declined to serve as public defender.
All right. Mr. Mitchell, you're charged with an aggravated domestic violence battery. I'm going to find probable cause for the offense. Does he have any priors?
No priors, Your Honor. Thank you.
Any contact with the victim advocate?
I did, Your Honor. She reported that she definitely wants him to stay away if she's in here.
Okay. Anything from you, pre-trial? Do you have priors on him? No priors on him. All right, Mr. Mitchell, what do you do for a living, sir?
I'm an ATM technician for Debo.
Okay. How much are you paid on average per month in your job?
Like 4,000.
Okay. Do you have any money in the saved in the bank or savings at home?
Yeah, yes, Your Honor.
About how much?
Like 2,000.
Okay. And do you own any properties such as a home or a vehicle?
Yes, Your Honor.
Okay. All right, sir. I'm going to set a $3,500 bond, and you're to have no contact with the alleged victim. Don't call, text, write, email, or try to find her on social media. Stay at least 500 feet away. Do you understand that?
Yes, Your Honor.
All right. Good luck to you, sir. Calvin Wilson.
Go down the middle and then go out to the right, okay? Sit outside there.
Calvin Wilson, come on up, please.
All right, Mr. Wilson, you're charged with an aggravated assault with intent to commit a felony and a domestic violence battery. I'm going to find probable cause for these offenses. Has the victim advocate any contact with the victim?
No, Your Honor.
All right. Mr. Linner, any priors?
Your Honor, I'm showing. One moment. Uh, 2007, 2 counts of aggravated assault.
Disposition?
Looks like he violated probation, so he was convicted on one of the counts, only violated probation on one count, so he kept a withhold on the other count. Ended up getting 180 days in county jail.
Okay. Mr. Romero?
Judge, and speaking of Mr. Wilson, he's been residing in South Florida his whole life. He is 28 years old. He's currently going to school. He goes to Florida Career College. He's studying to be a medical assistant technician. He's been with the program for 7 months now. He's set to graduate from that program in March. At this time, he's not working. He lives at the household. I did tell him that you'll be imposing a no contact order. He has no problem abiding by that order. He will need an order, however, to go one time with law enforcement to retrieve all his belongings. Financially, though, he has no money in the bank, no property. He's not working. His family was helping support him financially. So at this time, he has no sort of income, Judge. So we'd be asking you to set a reasonable bond and take into account his financial resources, which are basically zero at this point.
Okay. All right, sir. I'm going to set a $3,500 bond on count 1 and a $1,500 bond on count 2. You're to have no contact with the alleged victim. Don't call, text, write, email, or try to find her on social media. Stay at least 500 feet away. Do you understand that?
Yes, sir.
All right. Good luck to you. Raymond McClaim.
Your Honor,
Conti?
if I could have a moment.
Sure.
I'm being advised that Sheila, he's gonna be coming back tomorrow.
And what happened was you did a COC on the aggravated battery, I believe, count 1, and he was also ad charge, but they don't put the ad charge on top.
Okay.
So you can take care of count 1.
Well-
It's an upgrade from misdemeanor case.
I'm just gonna ask Your Honor if we could just take care of everything tomorrow morning.
All right.
If we were doing something that was going to keep him in longer, I would obviously not advise that. But since he's going to be back tomorrow anyways, I think it would just make more sense to deal with everything at the same time rather than piecemeal with something like this.
He'll be back tomorrow.
That's what we're being told by the jail. I'd ask him to be set for the morning.
I have no objection with being.
All right. All right. So I'm gonna and since there's no objection. I'm gonna resolve everything. Not resolve, but we'll handle the bonds on both cases tomorrow, sir.
And just so the court's aware, he's got no bond holds on court order, no bond holds, so he's really not being prejudiced by
Okay. You understand that, sir?
Yes, sir. But I also have a question about they have several charges, but they all have the same case number. They say cases once when I've been in here. Have 2017 case numbers on it, but I've been incarcerated since 2016, but they have 2017 case numbers. And I've been also in here over 33 days, and the charges haven't been filed. When all of a sudden they say change of charge.
That's going to be questions. That's going to be questions for your public defender, sir.
So I could tell him. Can I? Where is he at? Deputy? Can you take him by the phone? I'll explain to him what's going on.
All right, we'll reset this for Friday morning. Thank you. Carmen,
Judge, as a favor, deputies are asking if we could kindly call Mr. Gregory Russ out of turn. He's here at the main.
Sure. What was the last name? I missed it. Gregory
Russ, R-U-S-S. He's on page 13 of the docket. Mr. Russ, come on over here. Be careful, sir. Be careful. Yeah. Okay.
Okay, there we go. All right, Mr. Russ. Let's see. You're being held on 4 felony warrants.
These are refiles, Judge.
So they were already bonds on them previously?
That's what I'm going to check to see what the bonds were set at originally.
My understanding, Judge, the original case number was 15-1939 CFT. He was set for trial. I think state null process and refiled. He was arraigned on these charges yesterday in front of Judge Bailey. So I know he has a court date coming up. He's been in custody since February 11th, 2015.
Did Judge Bailey set bonds yesterday, do you know?
No, he
No.
did not. I know he's also being held no bond on VOP, though.
Your Honor, I'm pulling it right now.
All right, thank you very much.
Yes.
Yeah. You got
Yeah,
it.
that's what I'm just. Okay. Sorry, Judge. It's just.
No, you're fine. Take your time.
It's always something.
I mean, it's weird. You do that 2 years later, they thought.
Sheila, could you see what the bonds were originally on these charges? Because
It was, total was 16,000. For the aggravated battery, the first one was 1,000. I'm sorry, 10,000. Correction, 10,000. Second assault, was 5,000.
then there was a I'm sorry. Go ahead.
And then ag assault again with a deadly weapon, that was 5,000. And then ag assault again with a deadly weapon was 5,000.
And we would just ask that those same bonds be placed on him.
So 25,000 total? Okay. All right, then I will impose the same bonds that were originally on there, sir. Count 9, 10,000, and counts 10, 11, and 12 will be 5,000 each. There's going to be no contact with the alleged victim. Don't call, text, write, email, or try to find them on social media. Stay at least 500 feet away. Do you understand?
Yes, sir.
All right, all right. Good luck to you, Mr. Russ.
All right.
All right, let's see here. Carmen Brito Pernia.
Judge, it's going to be a medical reset, I've been informed.
No problem. So that'll be Friday afternoon.
Are we having an afternoon docket tomorrow?
Tomorrow, yes, it's next Friday that we're not having an afternoon docket, the 10th.
Oh,
Because
okay.
I wanted everyone on the team to be able to come to the ceremony.
I gotcha.
I could have gotten another judge to cover, but then you all couldn't have come, and you're very important to me, so I wanted to make sure you could be there. All right. So that's next Friday.
Thank you.
All right. Sandra Hall. File was posted? Okay. All right, I'm going to find probable cause. Alana Rodriguez. All right.
Hello?
All right. Oh, Miss Rodriguez, okay. You're charged with possession with intent to sell cannabis. I'm going to find probable cause for that offense.
Ms. Rodriguez is
Don't
currently
they cough?
supervised by pretrial services.
And this is admitted, he said.
16-14235 CF10A, possession of alprazolam. Based on the court's finding of probable cause, we ask that her pretrial status be revoked at this time.
Wait, let me see the one I handed you.
Thank you.
Keep it. Let me see the one I handed you.
All right, let's see what we're going to do here. I'll hold off on making a decision about that. What are some of her priors, if any, besides the possession of alprazolam?
Let's see.
Your Honor, I know that she was drug court eligible.
So that must mean she doesn't have any priors.
I know that there was an issue that they had with her, and something was going to be brought to the division judge because she came in, she didn't do the drug evaluation within 7 days as this court ordered her to do.
Okay.
And she also tested positive for, I'm looking to see what it says here, I'm sorry. Looking to see what she tested positive for. Cocaine and marijuana.
Who is she living with? Do you know? Pre-trial? Who do you live with, Alana?
I live by myself.
Where are your folks?
My mom, she has her own apartment, but she's handicapped.
And your dad?
He's never been in my life.
Got it.
Except for
I
mom.
understand. Your mom's physically handicapped?
Yeah, she's in a wheelchair.
She said she didn't want to go to the when we were trying to friend people.
But she didn't want to go. Okay. I'm going to revoke her pretrial status, case 16-014235 CF10A. No, you're going to have to see your division judge about that. Who's this been assigned to? Do you know?
This case, I don't think this case has been assigned to anyone yet.
The case she's out on pretrial for.
That right now is in front of Tobin Singer.
Oh, on her regular division, or it was transferred to drug court already?
No, it just immediately went into there. It looks
I
like.
see. All right. In this case, Ilana, it'll be $1,000 bond. All right. Good luck to you.
Thank you.
Got it. Yeah. Kazara Adams.
Paul Ryan.
All right. Paul Ryan, do you have Kazara Adams or Kazara Adams? Anybody over there at Paul Ryan?
I thought they said Paul.
Patrice, when you get a chance, do you mind calling over there for me?
Yeah.
Thanks. Oh, there he is.
Yes, Your Honor.
Hey, Deputy, do you have Kazara Adams?
It says Deerfield on the paper. I could look her up and see if she's here.
Okay. They're telling me that she's in Ryan, right, guys?
Brian and C2.
All right. Yeah, Charlie 2.
All right, I'll get her for you.
All right, thank you. All right. Well, it's not just me. It's hot in here, right? Okay, good. Just me and Sheila. All right, Jonathan Akins.
Mr. Akins is here present. Come on up, Mr. Akins.
All right. All right, how you doing, Mr. Akins?
Fine.
I just saw you recently, I think, right? Not too long ago? No, it wasn't you? Okay. Let's see. Sir, you're charged with giving false identification to law enforcement, resisting an officer without violence, violating a municipal ordinance of the City of Hollywood, probation or community control violation, a misdemeanor warrant, and 2 out-of-county felony warrants. On the municipal ordinance, which is count 3, I'm going to appoint an attorney to represent you free of charge. His name is Stephen Shate, and he'll be with you at your next hearing before that judge. I'm going to find probable cause. Bond on count 1 will be $100. There's no monetary bond on count 2. Count 3 is a $300 bond. Count 4, you're going to be held no bond. That's the violation of probation. Count 5 is the misdemeanor warrant. That's a $600 bond. Counts 6 and 7 are the out-of-county felony warrants. That's also no bond. You have a court date coming up for the violation charge on February 6th at 1:30. You'll see the division judge, okay?
For what?
I'm sorry, sir?
What's the violation court date for February 6th?
No,
That's for?
the February 6th court day is, I believe, for his outstanding capias on his misdemeanor offense. I believe his
you're right.
probation cases are out of Miami-Dade, so
I'm sorry, right,
he has a no bond hold.
yeah. So you're going to see your division judge in the misdemeanor court, the county court judge, okay?
Thank you, Judge.
All right, good luck to you. All right, Stephen Samuels.
Mr. Samuels, come on up, please.
Man, call for 5B.
Yeah.
They started out of sequence to count 4.
Mm-hmm.
I believe this is Broward violation. See the CF pictures?
No.
No?
No. Count 4? I don't see any case number.
Do I have probation with them?
No. It's 4 of the same charge. This is Stephen Samuels.
No, Jonathan Atkins.
Oh, Jonathan. We're back on Jonathan Atkins. Okay, that is a count 4. Yeah, is a Broward violation. Yeah.
All right. All right.
but they don't have a court date set up for his VOP for that. Mr. Romero is right. It's for this misdemeanor.
Yeah.
It's Division MP. All right. Mr. Samuels.
Yes, sir.
All righty. So, sir, you've been charged with some felony offenses. Mr. Romero, you want to waive a formal reading of these charges?
Yes, Judge, I do.
All righty. All right, Mr. Samuels, your attorney will explain to you exactly what those charges are. I'm not going to read them out loud. I will find probable cause for the offenses. Does he have any priors?
Yes, Your Honor. The state is going to be seeking a significant bond and pretrial release with a GPS monitor, based not only on the allegations and, frankly, the strength of the evidence, but also the potential consequences Mr. Samuels shall be facing if convicted. 2009, resisting with violence, attempting to deprive an officer of a weapon or communications device. He was sentenced to 5 years in a day state prison as a habitual offender and PRR offender. Does pretrial have when he was most recently released? While she's looking, 2008, felony battery, great bodily harm with the violation of probation, 5 years state prison. 1999, aggravated stalking, violating an injunction, and 2 counts of grand theft auto, 64 months in state prison as a PRR offender. 1999, aggravated stalking, violating an injunction, improper exhibition of a weapon and criminal mischief, 64 months state prison as a PRR offender. He pled out a felony offense to misdemeanor battery in 97. 1997, possession of a firearm by convicted felon and carrying concealed firearm, 18 months state prison as a habitual offender. 1997, possession of cocaine with a violation of probation, 18 months state prison. 96, possession of cocaine. 95, possession of cocaine. 94, strong arm robbery with a violation of probation. 1994, battery and assault. So, Your Honor, in addition to the consequences he's facing, he has priors that involve violence in his past. He has a prior for being in possession of a firearm when he wasn't supposed to be. He has priors for not following court orders and stalking people that sought protection from the court. And he has at least one battery in the past where he caused someone great bodily harm.
All right. Mr. Romero?
Judge, in speaking with Mr. Samuels, he's 41 years old. He's been living in South Florida his whole life. He is currently employed. He works for PBS General Labor. He deals in construction. He makes approximately $8.10 an hour. Financially, though, he has limited resources. He has no money in the bank. He lives in Fort Lauderdale with his father. They've been residing in the same apartment for about 3 years now. His monthly rent is about $850. Mr. Samuel's father is the only person who's going to be able to help him post bond, but the gentleman is elderly. He is retired. He's worked in asphalt his whole life. He has very limited funds, Judge. We ask you to set a reasonable bond as to Mr. Samuels.
All right. I'm going to set a $50,000 bond on count 1, $50,000 on count 2, $25,000 on count 3, and $25,000 on count 4. Pretrial release level 1, the GPS monitor. And sir, you're to have no contact with the alleged victim. Don't call, text, write, email, or try to find her on social media. Stay at least 500 feet away. Do you understand?
Yes, sir.
All right, good luck.
Your
Randy?
Honor, this is Paul Ryan.
Yeah.
Conti facility has someone working on their cameras. They just arrived. They have 2 people there. They'll, with the court call their people out of turn.
Oh, they're ready for me now?
Yeah.
Oh, yeah, sure, no problem. Who are they?
Your Honor, Paul Ryan.
Sanchez, who do you got?
I got Casey Myers. All right, I'm gonna get back to her in just one moment, okay? All right.
Okay. All right, sir.
All right, Conti, I've got you, Conti. Who's the who we got?
Myers.
He's on page 14. Casey Myers, okay. Change of charge, or I have it as a violation of community control?
Yeah, it's a change of charge from one type of aggravated battery to another type.
All right, so then the clerk's sheet is incorrect. I'm just going to change that. It's aggravated battery with a deadly.
It was now aggravated battery firearm. I'm
What
getting
was
it.
the bond? All right. I'm going to find probable cause for aggravated battery with a firearm. There is no violation of community control. That's a misprint. I'm going to find probable cause. I'll set bond at $25,000, and there's going to be no contact with the alleged victim, sir. Don't call, text, write, email, or try to find them on social media. Stay at least 500 feet away. Do you understand that?
Yes, Your Honor.
All right. Good luck to you, sir.
Can I say one thing? Or press one? Your Honor, I wasn't in possession of no firearm.
Oh, I would encourage you not to talk about the facts of the case, sir.
Okay.
All right? All right, good luck.
Yes, Your Honor.
And Reyes, Tony on the second look, motion for release.
Okay, great.
One moment, Judge.
Thank you. Tony Reyes, okay.
Your Honor, Mr. Reyes, we've not filed an information. He's entitled to release. I would just ask that Your Honor remind Mr. Reyes that the no contact order is still in place.
I will.
Thank you, Judge.
All right, Mr. Reyes, so the state hasn't filed charges yet. You're going to be released on your recognizance. Doesn't mean the case is going away, so that no contact order is still in effect. You got to stay 500 feet away from the alleged victim. Don't call, text, write, email, or try to find her on social media. Do you understand?
Yes, sir.
All right, good luck to you, sir. You'll be released on your recognizance.
Thank you.
All right, thank you, Deputy.
Thank you, Judge.
No
Boz,
problem.
thank you.
All right, back to Paul Ryan. We now have Miss Adams.
Adams.
Okay, very good. Ma'am, you're charged with possession of PVP, possession of cannabis, and you're being held on a felony warrant for grand theft auto. I'm going to find probable cause. A $1,000 bond is on count 1. There's no monetary charge count 2. Count 3 is a no bond hold. You'll see Judge Bober on February 7th at 9 to address the charge. All right, good luck.
Yes, sir. Thank you.
Randy Noggle.
Mr. Noggle, Randy Noggle?
Noggle.
Hold on one moment.
No problem.
Randy. It's kind of cold in here, Judge.
No problem at all. All right, Mr. Noggle, you're charged with possession of heroin, possession of drug paraphernalia, violation of your probation or community control 2 counts, and 3 felony warrants. I'm going to find probable cause. Bond on count 1 is $1,000. There's no monetary charge on count 2, and no bond on counts 3 through 7. You have 2 court dates coming up. The first is on February 6th at 8:30. The second is on February 7th at 9 a.m. to address those felony charges. Good luck, sir.
Thank you.
Sure. Wayne Macello.
Mr. Macello is here present, Judge.
All righty.
Wayne Macello, come on up. He declined to serve as a public defender, Judge.
All righty. All right, Mr. Macello, you are charged with possession of cocaine, possession of drug paraphernalia, and 4 counts of violating your felony probation. I'm going to find probable cause. Count 1, the bond to be $1,000. Count 2, there's no monetary charge. Counts 3 through 6, there's going to be no bond, and you'll see your division judge, Judge Robinson, Michael Robinson, on February 7th, 8:30 a.m. Good luck.
Sure, thank you.
Nicholas Peterson.
Mr. Peterson, I've been advised he was bonded.
All right, I'll find probable cause. Brandon Rogers.
Been advised medical loan.
Okie dokie. This will be Friday afternoon. Luis Mendoza.
Mr. Mendoza is here present, Maine.
All righty, Mr. Mendoza, you're charged with violating your felony probation. You're going to be held without bond at this time. You'll see your division judge on February 7th at 9. All right, good luck to you. That's Judge Bober.
Patrick Marshall. Come on up, please.
Judge Patrick Marshall was already county sentenced on his VOP.
On this VOP, so this I'm not going to take any action here today. All right. It indicated that he had a court date on 2/6. Is that all?
We have
All right, so I'm being told that Judge Shear has already issued a sentence in this case on this VOP, so on this violation. I'm not going to take any action today, sir. Were you recently in front of Judge Shear?
Yeah.
Okay.
Yes, sir.
All right, good.
Yes, sir.
All right, so I'm going to take no action then today, and the jail will update the information? 120 days, okay. All right, you're aware of that, sir? You remember?
I couldn't hear what was said. What was said?
I just want to make sure, so you were aware of that? You were in court yesterday with Judge Shear, you know what she said?
Yeah, 120 days, and I had
Okay.
to complete a program.
Okay, good. All right, good luck to you. I hope that works out.
All right, thank you.
All right, be safe. Take care. And Linwood Hannah.
Mr. Hannah's here present, Judge?
All right, Mr. Hannah, you're charged with a violation of your felony community control. You're going to be held without bond at this time. You'll see Judge Shear on February 6th at 8:45 a.m., sir. Good luck.
Yep.
Thank you, sir.
We have one more gentleman here at Maine.
All right.
Christopher Stazowitz. You were here in the morning, though?
Yeah.
Oh, it was. He said he was here in the morning?
I was here in the morning and they sent me back because they said that it got changed to PM.
Oh, yeah, that was the case that...
Let me look at this morning's docket, Judge.
I'm sorry, what's your name, sir?
Christopher Stazowitz?
Oh, we do have it. Okay, great. We do have it. Good. Thank you. So there needs to be a change in count. Which count was it? Count 3? What I have here is driving with a suspended license, speeding in a school zone, possession of cannabis with intent to sell, and possession of alprazolam.
That's what I was on
For
probation.
probation violations. Those are correct? That's been corrected? Okay, very good. All right, sir. You're charged with driving with a suspended license, unlawful speeding in a school zone. You got 2 felony warrants. Wait, felony warrant or probation violation?
Probably.
I have them both as habeases. So these are VOPs. Counts 3 and 4. Okay. That's what needed to be corrected. All right. So 2 counts of violating your felony probation. I'm going to find probable cause. A bond on count 1 to be $100. There's no monetary charge on count 2. Counts 3 and 4 is no bond. And you're going to see your division judge on February 7th at 8:45 to address those charges, okay?
Yes,
All right,
sir.
good luck to you, sir. All right,
Thank you, Judge.
Thank you, Mr.
We're all
Ramirez.
done here at Maine. You
All
guys
right,
have a
see you
good night.
tomorrow. All righty. Yes.
I'm sorry, Christopher, on your findings, can you use the 3 and 4?
I put in VOPs. Yeah, I already did it. Took care of it. All right. Let's see who's got what left. All right, there we go. Are you Mr. Williams or Mr. Skaggs?
Mr. Skaggs was released.
Oh, Skaggs was released. So you're Michael Williams?
Yes, sir.
All right, very good, Mr. Williams. Is he here on a 30-day or a second look?
30-day.
All righty.
Your Honor, we've not yet filed. He's entitled to release. It's looking like this case is going to end up being a decline.
Okay. But for now, the no contact order will still be in place.
He just needs
notice.
What he should do, my advice is, he obviously has a public defender. They filed the motion.
Right.
He should stay in touch with his attorney, who can update him as to the status of the
Okay.
case.
Do you know who your public defender is, sir?
Yes, sir.
All right. You have the phone number?
Yes, sir.
Okay, very good. Today you're going to be released on your recognizance. There's still a no contact order in effect. The state is telling me that this case will likely be declined, but it hasn't been declined yet. So you're going to have to stay in touch with that public defender. He'll keep you posted on the status, okay? If you don't hear
Yes,
from
sir.
him, if he doesn't call you or she doesn't call you, you call them, okay?
Yes, sir.
All right, good luck to you. So you're released on your recognizance. Good luck.
Thank you, sir.
All right. All right, everyone. Thanks so much. See you tomorrow.